Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. If policy whiplash and mounting caseloads are draining the joy from your practice, you're not alone. You became a lawyer to help people build new lives, not to drown in paperwork and rework cases amid shifting political winds. That's why the experts at e-Immigration by Serenade created the Certainty Factor, a free guide showing how purpose-built AI tools can create stability in your practice without sacrificing the human touch. Featuring insights from top innovators in immigration law, Serenade is sharing ways to implement AI so you can be a strategic advocate again. Download the Certainty Factor today at eimmigration.com/certainty and put the heart back into your practice. Again, that's eimmigration.com/certainty or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. So much litigation. How about that Judge Ho concurrence on the Supreme Court's Alien Enemies Act remand? Somewhat humorously named the AARP litigation because of the acronyms of the plaintiff. From Judge Ho in an unnecessary concurrence on remand, quote, "It is not the role of the judiciary to check the excesses of the other branches any more than it is our role to check the excesses of any other American citizen," end quote. Oh my. I must have gone to the wrong law school. Or how about the Fourth Circuit, ordering the U.S. government to again, quote, "facilitate," end quote, the return of someone else that the U.S. government has illegally removed in the JOP litigation. Wild times. I just quoted Judge Ho, so I might as well quote Fourth Circuit Judge Gregory, quote, "As is becoming far too common, we are confronted again with the efforts of the executive branch to set aside the rule of law in pursuit of its goals. It is the duty of the courts to stand as a bulwark against the political tides that seek to override constitutional protections and fundamental principles of law, even in the name of noble ends like public safety. The district court faithfully applied the contractual provisions in dispute here, and it properly ordered the United States to remedy the violation of its explicit promises. I cannot more fully concur in the denial of the stay pending appeal in this matter," end quote. That is the government's attempt to stay the district court's order. Somewhat of a different judicial philosophy from Judge Ho, from Judge Gregory, it seems. 4 cases discussed on the podcast this week, all again not great for non-citizens. Hope it's not a trend. Plus another from the Second Circuit, so technically 5 cases, Zia v. Bondi, holding that INA Section 242A2BI bars district courts of jurisdiction to challenges of USCIS's denial of an adjustment of status application. I could do the whole decision, but why? There it is. The dicta ghost of Patel strikes again. The Second Circuit joining many circuits to have so held already, too. Rough times, everybody. Here's your 4. Our first case, United States v. Doe, published by the 11th Circuit on May 21st, 2025. This is quite the case. It's a criminal one, making it adjacent to the core of the show, but how could I not? As the 11th Circuit explains, Mr. Doe has at least 9 aliases, all listed at the top of the case. His immigration history goes all the way back to 1985, when he twice tried to enter the United States under two different names and using fraudulent documents. He was ordered excluded, and he was deported the second time, says the 11th Circuit, but it was probably just exclusion if I'm being honest, but who knows? He showed up in Texas 3 years later, claimed to be a U.S. citizen, and was deported. Don't know what happened over the next couple of decades, but he was detained by ICE in 2018. ICE reinstated the 1988 deportation order and served Mr. Doe with a, quote, warning for failure to depart, end quote. The warning informed Mr. Doe of the, quote, criminal penalties under 8 U.S.C. section 1253A1 for obstructing his removal or not cooperating with the procedures for obtaining travel out of the country, end quote. There's definitely an INA corollary for that statute, but we're just going to leave it at the 8 U.S.C. because I am tired, and this is a criminal case. Mr. Doe, however, refused to help out with his removal and didn't provide basic biographical information to help a consulate, any consulate, identify him or who he was. Quote, when the officer asked what his name was, Mr. Doe proclaimed that, quote, only God knows my name, end quote, and then end quote that quote. Seems like he might be Jamaican, but he's not being very helpful about it. Multiple times. So the federal government indicted him under Section 1253A1. That section makes criminal, quote, those who willfully disobey or hamper removal orders that are issued because they are a member of any of the classes described in, end quote, INA Section 237A. So we're in criminal world, but it incorporates the removal provisions. Seems like there really isn't that much of an argument that he didn't willfully hamper his removal, at least not at issue before the 11th Circuit. But is Mr. Doe a member of a class of people described in Section 237A of the INA? He is, said the District Court and the 11th Circuit, affirming the conviction. Section 237A covers a lot of grounds of removal, so, one's gotta fit Mr. Doe, right? The federal government chose the first one, INA Section 237A1A, a non-citizen, quote, who at the time of entry was within one or more of the classes of non-citizens inadmissible by the law existing at such time, end quote. We don't know how he entered, that is Mr. Doe, but we know it wasn't lawful. We think. Mr. Doe's arguments were mainly about jury instructions, but that's for the criminal podcast to do. For our purposes, the 11th Circuit held that the criminal statute does not require proof of a lawful admission or that the initial removal order occurred under Section 237A, which totally didn't happen here, right? Because it was a deportation order or maybe an exclusion order, but definitely before Section 237A even existed. To qualify for this criminal statute, it's just, I suppose, that the individual is potentially removable under Section 237 and is willfully disobeying or hampering his removal. Lots of text-based analysis by the 11th Circuit to get here, but most compelling to me at least is that the criminal statute uses the phrase, quote, member of any of the classes described in, end quote, Section 237A. Not necessarily found removable in the past under Section 237A. The 11th Circuit also goes through some legislative history, beginning that portion with an excellent description, quote, we need to travel through some of the modern immigration law's history. Like Frankenstein's monster, modern immigration law was assembled piecemeal from quasi-dead bodies of law, end quote. Indeed. And a nice little history from the court, from pre-IIRIRA to today. What a crazy area we practice in. Part of the problem here, or maybe confusion, explains court, is that although terms and concepts have changed, like exclusion and deportation, quote, Congress left from the old deportation regime the criminal penalties for non-citizens who failed to leave the country after an order of what is now called removal, end quote. But criminal penalties still apply to the pre-IIRIRA exclusion and deportations that are now called removals. Confusing, right? But I'm buying what the 11th Circuit is selling, personally. To be clear, Mr. Doe made a lot of smart text-based arguments that I have not done justice because we'd be here all day if I did. But at the end of the day, the 11th Circuit wasn't buying Mr. Doe's reading of the statute, and he remains convicted. So take note, everybody. Your Section 237 removal clients with final orders of removal need to comply with ICE's lawful requests that they participate in trying to get travel documents and stuff like that, or they could be in criminal trouble. This decision makes that quite clear. And if you have read this very textually complicated decision and think that I've missed something relevant to removal defense and immigration practice generally, my email is all ears. And that is United States v. Doe. Next is Ramos Goncalves v. Bondi, published by the First Circuit on May 20th, 2025. This case is about untimely petitions for review. As such, the petition was dismissed. But the First Circuit saw fit to publish the decision, so obviously it's a bit more complicated than that. Mr. Quinn Goncalves married after filing his petition for review and changed his name, so the First Circuit uses his married name. He appears to have been detained for some time and filed his petition for review 3 days after it was due. At least that's when the First Circuit received it. His wife mailed it for him on the last day it was due, after allegedly being told by a clerk of the court that she could do it. Now, under the federal rules of appellate procedure, circuits apparently cannot extend the petition for review deadline for any reason. Quote, he nevertheless contends that we may address the merits of this petition through a post hoc extension of time for the clerk to receive the petition, and that good cause exists for us to do so, end quote. Not gonna lie, I wouldn't have thought of that argument. To Mr. Goncalves, that the statute and the federal rules have a non-extendable deadline, quote, to file, end quote, a petition for review doesn't answer the question on whether the time to receive the filing can be extended for good cause. To Mr. Goncalves, he filed his petition for review on time, mailing it within the 30 days. But it just took a couple of days to arrive at the First Circuit and be received. You should be able to extend that, he argued. The First Circuit disagrees, quote, a petition for review mailed but not timely received within the time fixed for filing falls within Rule 26b2's prohibition on the court granting time extensions, end quote. Not for nothing, though. Courts have had forgiving rules for prisoners for a long time, recognizing the inherent difficulties they have mailing legal documents on time. But Mr. Goncalves' situation is different. It's a different statute. He actually had the option of using an electronic system, too. And also it was his wife who mailed it for him anyway. They weren't using the prison system like in all that mailbox rule prisoner case law, but were instead using normal UPS mailing. While the arguments made through counsel are quite wonky, are statutorily based, and are not frivolous, the First Circuit believes a better reading of the rules requires that circuits receive the filing to accomplish it, not mere mailing. At least when the mailing is occurring outside of prison, as occurred here. I don't know, read the decision. Maybe it is true that immigration detainees can benefit from the mailbox rule if they timely mail their petitions for review, even if it's not received by the circuit on time. I'm not sure. And certainly don't rely on me for all that, and I'm not sure what the podcast listenership is in immigration detention centers anyway, so I'm not overly worried of misadvice there. But actually, if you're listening to this podcast from an immigration detention center, I want to speak to you and learn your story immediately. Here, though, from Mr. Goncalves, who did not actually mail his petition for review from a prison, and who the First Circuit says the filing deadline can never really be extended, he has missed his shot for circuit review. And that is Ramos Goncalves v. Bondi. Adapt, change, evolve, stay ahead. Immigration law is moving faster and demanding more every day. Clients need help, the pressure's building, and you're doing everything you can. But there's only one of you. You don't need a clone, you need Staffy. Staffy's bilingual virtual paralegals, case managers, and admin assistants handle USCIS forms, client intake, evidence gathering, and scheduling so you can focus on the cases and not the chaos. With Staffy, you get a full trained representative and an HR-backed team that's ready to go. Staffy handles onboarding, coaching, and continuous training so you don't have to. You weren't meant to do this alone. Schedule your staffing strategy session at www.staffy.cc, that's staffy.tc, and get $500 off your first month. Or, of course, click on the link in the show notes. Welcome back with Gonzalez-Juarez v. Bondi, published by the Ninth Circuit on May 20th, 2025. This case is about hardship review, a common topic of late after the Supreme Court's Wilkinson decision. There are very little facts provided about Mr. Gonzalez-Juarez's actual claims, but suffice it to say, he lost the non-LPR cancellation of removal case before the immigration judge and BIA based on a finding that he could not establish that a qualifying relative U.S. citizen child would suffer exceptional and extremely unusual hardship if he was removed. Before the Wilkinson decision from the Supreme Court, it's possible that the issue might not have even been reviewable at the circuit. The panel here says it was not in the Ninth, at least. Post-Wilkinson, though, it's definitely a reviewable issue at the circuit court level because it's considered a mixed question of law and fact. That is, whether agreed-upon facts meet the exceptional, extremely unusual hardship legal standard. But what standard of review are circuits to apply? The non-citizen-friendly de novo review or the agency-friendly substantial evidence review? As quite a few decisions have held of late, it's substantial evidence. Lots and lots of legal nerd pages to explain why, so here are the highlights. The main reason, explains the Ninth Circuit, is that despite being a mixed question, the court believes that whether an agreed-upon set of facts meets the hardship legal standard is one governed largely by, quote, case-specific factual issues, end quote. When factual review is at play rather than purely legal, substantial evidence rather than de novo is the standard. The panel believes that more apt here, citing to a bunch of non-immigration case law. Quote, the court that has the closest connection to the facts is the immigration court, presided over by the IJ, end quote. Applying substantial evidence review here would also align with the standard of review applied in other petition for review immigration contexts, explains the panel, citing to a lot of Ninth Circuit immigration precedent, much of which has been discussed on the podcast. The court believes that this rule aligns with the Third Circuit's own approach on the Wilkinson decision itself on Remand Episode 255. The Ninth Circuit then went through some recent Ninth Circuit case law to distinguish why, unlike in those cases, the abuse of discretion standard was not the appropriate standard of review. Which, to be honest, is a somewhat favorable holding for non-citizens, given how hard that standard is to overcome, if we're picking up breadcrumbs. And by the way, when tethered to non-LPR cancellation of removal or the other reliefs listed at the jurisdiction stripping provision, the court here explains that even after Wilkinson, it can't review things like, quote, an IJ's fact-finding on credibility, the seriousness of a family member's medical condition, or the level of financial support a non-citizen currently provides, end quote. So just keep that in mind. Really need to make your record clear below. So after stating what the standard of review is, and again, it's going to be favorable to the agency, the Ninth Circuit goes to some of the facts of the case here. But not before defining what the hardship standard means. As the Ninth Circuit explains, dictionaries explain that exceptional means, quote, out of the ordinary course, unusual, special, end quote. Extremely means, quote, in an extreme degree, exceedingly, very much, end quote. And unusual means, quote, not usual, uncommon, exceptional, end quote. Put that together and what do you got? Quote, the hardship must be out of the ordinary and exceedingly uncommon. It must deviate in the extreme from the norm. The agency must compare the hardship in a given case to the hardship that results in the usual, ordinary course when a non-citizen is removed. The BIA has held similarly for a while now, explains the Ninth Circuit, relying on Monreal Aguanaga from 2001. And although that doesn't bind anymore, the Ninth Circuit believes it's instructive. That standard was unmet to the panel in this case for a couple of reasons. For example, from that 24-year-old BIA decision, quote, a lower standard of living or adverse country conditions in the country of return generally will be insufficient in themselves to support a finding of exceptional and extremely unusual hardship, end quote. As the BIA has explained and the Ninth Circuit has adopted, the only type of hardship that can permit a non-citizen to stay in these circumstances is hardship, quote, substantially beyond the ordinary hardship that would be expected when a close family member leaves the country, end quote. Mr. Gonzalez is from Mexico and living in the United States for 26 years, but that still didn't meet it. Well, I mean, he did meet it before the IJ. The IJ granted relief, but the BIA reversed on DHS's discretionary appeal. The Ninth Circuit panel decided it would not overturn the BIA, exercising the deferential substantial evidence review that applies to the BIA and not the IJ. The Ninth Circuit held that it would not be reversing the BIA. Mr. Gonzalez's sons, for example, were older teenagers, and they would join him if he was removed. And although they weren't fluent in Spanish, they spoke some Spanish. One had eczema. And also country condition evidence showed significant crime in Mexico. But that significant crime applies to all Mexicans, explains the Ninth Circuit, so it isn't overly instructive. Quote, a country conditions report that applies equally to a large proportion of removal cases does not compel the conclusion that the hardship standard is met, end quote. Not going to lie, that's a little surprising to me, as I would think that the hardship comparison concerns all potential removees, not whether one's hardship is worse than the average removee to a specific country. So maybe I'm misunderstanding the Ninth Circuit's quote, and maybe I'm making up the word removee. But rejecting other arguments, the Ninth Circuit denied the petition for review. And that is Gonzalez-Juarez v. Bondi. Landing with the Second Circuit, with Singh-Kar v. Bondi, published by the Second on May 21st, 2025. This is an Indian Sikh asylum decision. Mr. Singh-Kar's father is a member of the Man Party. Mr. Singh-Kar testified that he was twice attacked by the rival Patel party, both Sikh political parties if I'm not mistaken. Mr. Singh-Kar isn't a member, it seems, but it also seems that he was working for the Man Party, as he supports the Man Party's goal of establishing a separate Sikh state known as Khalistan. He was stopped while riding home from a school in 2016 and told to stop working for the Man Party. When he refused and voiced support for Khalistan, quote, the people hit him in the legs with a hockey stick, threw him to the ground, and told him that they would kill him and his family if he did not join the Patel party, end quote. Mr. Singh-Kar and his father went to the police station to report it, but the police eventually slapped Mr. Singh-Kar in the face twice and threw him out. They said they wouldn't help, quote, Khalistani people, end quote, and threatened to arrest Mr. Singh-Kar and his father. Some months later, Patel party members threatened to kill Mr. Singh-Kar. Deemed credible, an immigration judge denied the claim, finding the harm insufficient for past persecution, noting that some of the testimony was inconsistent, and also denying Convention Against Torture protection. The BIA affirmed. The BIA also rejected an ineffective assistance of counsel claim made for the first time on appeal. Now, obviously, to get asylum, you need to show that you fear the government or individuals that the government is unable or unwilling to control. The slap by police didn't cut it to the Second Circuit, at least for direct government persecution. As to private actor persecution, quote, a close relationship between government officials and private persons may be probative of the former's unwillingness or inability to control the latter. But the relationship alone does not transform the private persons into government actors, end quote. That wasn't present here either, explained the court, sufficiently to satisfy the asylum government nexus element. Members of a political party, at least the Patel party that isn't controlling the Indian government at present, don't cut it. Police did refuse to help him though, right? Well, to the panel, quote, testimony that the police failed to assist a petitioner on one occasion without more does not establish an entire government's inability or unwillingness to protect, end quote. I like that Khalistani people remark, though, from the cops. I mean, I hate it, but I like it legally for an asylum claim. I wonder if more can be done with that, if it happens in another case in the future. But in any event, the court also didn't see a case based simply on the country conditions report in the record, which included a report from the Refugee Board of Canada. Don't sleep on that report, I bet, especially for Indian claims. And particularly as it seems that the Department of State in the United States is about to be gutting its reports for political reasons. Nor did the panel see a problem with the immigration judge giving little weight to a letter from a man party secretary. Nice piece of evidence if you can get it. But the Second Circuit didn't see a problem with giving it little weight because courts appropriately, quote, accord little weight to letters from interested parties who are unavailable for cross-examination, end quote. Cat denial was summarily affirmed, and so on to ineffective assistance of counsel. On that, and at a minimum and as required for such claims, quote, the BIA correctly concluded that Mr. Singh-Kar had failed to show that he was prejudiced by his previous counsel's performance, end quote. The Second Circuit doesn't see an asylum or CAT grant, even if the country condition reports that former counsel apparently did not submit had been submitted. Man, hope a bar complaint wasn't filed. Ineffective assistance of counsel is rough stuff. Rejecting the arguments, the Second Circuit denied the petition. And how about this? Somewhat addressing the elephant in the room, and admittedly, something I had thought but had decided not to say, quote, this case presents a fact pattern that our court has repeatedly considered, end quote. String citing to its own Second Circuit precedent and a footnote nonetheless. And if you think that's true, Second Circuit, just go check the Ninth. But I'm not sure actually what the Second Circuit means by this. They don't say that Mr. Singh-Kar or all those other cases were not credible. They just list them. So maybe they're listed just to show that here, the Harmon factual record is insufficient, like in those other cases. And of course, as always, all of this might equally mean that similarly bad things are happening to similar people in India, albeit not to the level of past persecution in most cases. Or not. Case-by-case adjudication. And that is Singh-Kar v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.